Hello to everyone. Welcome. My name is Florence Laffer. I'm the director of Prison Insider, and I'll be moderating this webinar. I'll start with a few practical points just for organization. As you've seen, interpretation is available in English, in French, in Spanish, and in Catalan. To activate it, you need to go at the bottom of your Zoom window on the little planet icon, and you can click on the language you want to select. If you have any problem, first make sure that you do have the latest version of Zoom. You can also try clicking on the mute and unmute button. And if there's anything, of course, you feel free to email the tech team in the Q&A session. So welcome to everybody. This webinar is the third of a series co-hosted by Diana Riba-Enginer, Green EFA, Spanish member of the European Parliament, co-hosted with Prison Insider. And today's focus is on alternatives to detention and on non-custodial measures. Prison Insider is an information platform on prisons in the world. Our work is to inform, compare, and share testimonials on condition of detentions with regard to fundamental rights. About today's issue, non-custodial measures are known to provide an alternative to detention, and we know that this is widely recognized as a means to reduce overcrowding. Non-custodial measures are often understood as a tool for social reintegration of prisoners and is seen as a way to reduce reoffending. On the other hand, research seems to show that effects of alternative measures are positive only when they're part of broader strategies of structural penal reforms, such as decriminalization and diversion programs. It's also seen that the introduction of alternatives in certain cases can have unintended negative impacts. For instance, when new sanctions are created or are there to respond to offenses and to situations that previously might have not been criminalized. So our question today is to explore, or the question we want to explore is, how are European countries implementing alternatives to detention? And is it possible to avoid the risks of this net widening effect? To start, I'd like to give the floor to Diana, member of European Parliament, who will give us a few words of welcome. Diana.
Thank you very much, Florence. Good morning, everyone. I will speak in Catalan, so please change the interpretation now to any of other language available in case you need it. Bon dia a tothom i gràcies per acompanyar-nos avui en aquesta conferència. En primer lloc, m'agradaria donar les gràcies a totes i tots els ponents per haver acceptat la nostra invitació. També vull agrair a Prison Insider, especialment a la seva directora, la Florence Laffer, i al seu equip la col·laboració en aquesta coorganització d'aquest cicle de webinars, que, com ha dit la Florence, avui és el tercer, i que tenen aquest objectiu d'introduir a l'agenda política de la Unió Europea la necessitat de legislar en l'àmbit de la presó preventiva i en les condicions penitenciàries. Avui tindrem l'oportunitat d'escoltar diferents experts reflexionar al voltant d'aquestes alternatives a les presons i a les mesures no privatives de llibertat, dels seus beneficis i dels reptes que comporten, tant a nivell institucional com a la seva conscienciació social i ciutadana. En un recent informe publicat per l'Oficina de Nacions Unides contra la droga i el delicte ho afirma amb rotunditat i diu així que l'ús excessiu de l'empresonament és un greu problema a tot el món. I no només ha resultat ser ineficaç amb els beneficis limitats per la seguretat pública, sinó que també ha donat lloc a significatives violacions de drets humans comeses contra persones privades de llibertat, com ara pot ser el maltractament, sotmetiment a condicions inhumanes, a superpoblació de les presons, per exemple. Hem de recordar que les regles mínimes de les Nacions Unides sobre les mesures no privatives de llibertat, aquestes regles anomenades les regles de Tòquio, consideren que un sistema de justícia penal hauria d'establir una àmplia gamma de mesures no privatives de llibertat, des de la fase anterior al judici fins a la fase posterior a la sentència. I això ha de ser compatible amb un tipus i la gravetat del delicte sobre la personalitat i els antecedents de l'acusat i la protecció de la societat i evitar aquesta aplicació innecessària de la pena de presó. En les últimes dècades, en determinats sectors polítics, socials i també mitjans de comunicació, amb freqüència han exigit aquest sistema penal que siguin punitius i que apliquin polítiques públiques que tinguin més probabilitat d'empresonament. I fins i tot han demanat aquest enduriment d'algunes penes. I des del convenciment que tancar les persones per períodes llargs de temps comportarà o sigui, tenen el convenciment que aquestes penes llargues de presó comportaran un descens d'aquesta criminalitat. No obstant això, hi ha poca evidència que això passi i que suggereixi que aquesta amenaça de llargues penes a la llarga sigui un factor dissuasori o que per majors nivells d'empresonament la seguretat ciutadana augmenti. Tenim moltes poques evidències que això es digui així. Per contra, tenim diverses investigacions que demostren que, tot i que evidentment l'empresonament, que una persona pugui evitar temporalment aquest empresonament, cometi després delictes fora de la presó, i això per si sol no redueix la reincidència, sinó que pot inclús incrementar la delinqüència després de l'alliberament. Amb tot això estaríem generant precisament l'efecte contrari, augmentar les penes de presó i que hi hagi més durada del tancament a la presó pot comportar fins i tot una conseqüència a l'inversa, que seria una societat menys segura. Com a parella d'una persona que ha estat empresonada més de 3 anys i mig i amb fills que tenim en comú, ho puc dir amb coneixement de causa, que la presó trenca o en els millors dels casos esquerda els llaços afectius i fet que dificulta enormement la rehabilitació després d'aquestes persones a la nostra societat. Per tot això, i crec que és molt pertinent i necessari el webinar d'avui i aprofundir en el coneixement de les mesures alternatives a la privació de llibertat, dels seus beneficis a les persones i a la societat en general, i també que ens aturem, si cal, en els seus possibles inconvenients i com sortejar-los. Finalment, i abans de donar la paraula a tots els ponents, m'agradaria agrair la presència de tota la gent que ens està seguint, des de la societat civil, gent del Parlament Europeu, de la Comissió Europea o representants dels estats. Crec que és una molt bona senyal a l'interès que ha suscitat aquests webinars i, per tant, seguirem treballant en aquesta bona direcció col·lectivament. Així que comencem. Moltes gràcies, Florence, per donar-me la paraula.
Thank you, Diana. I'm happy to be introducing now our very distinguished panel composed of a number of experts. I'll start first with Catherine Hurd. She's the director of the World Prison Research Program at the Institute for Crime and Justice Policy, Birkbeck, University of London. And ICPR has recently finalized an evidence-based penal reform project called Understanding and Reducing the Use of Imprisonment in 10 Countries, which is a very impressive set of reports and a very solid base of evidence. And Prison Insider has been very happy to partner with ICPR in the final stages of this project. Then we have Matilda Pogorzelska, and she's the project manager and legal researcher in the European Union's Fundamental Rights Agency. Very happy to have you with us. And we also have Alessio Scandura. He's the coordinator of the European Prison Observatory and works at Antigone, an Italian NGO that promotes human rights in the criminal justice system. Now, very practically, we're planning for about 1 hour of webinar, which means we'll be having rather short presentations in order to leave some time at the end for a Q&A session from the participants. All participants have their microphone muted by default. So the way to ask your questions is to go in the Q&A sections. The panelists and myself are seeing all the questions. Some questions might be responded to or answered to directly in the Q&A sessions, and we will be picking a number of other questions to start the discussions. I'd like to start first by inviting Catherine to give us a few insights. In your report, in ICPR's report, what patterns of imprisonment have you noted in Europe, and what do you think the role of alternative approaches can be in changing these patterns?
Thank you. Thank you so much, Florence, for the introduction, and thanks to Diana for hosting this important discussion today. I'm really delighted to see the European Parliament renewing its focus on this key area. So yes, to answer those two questions, firstly, what patterns of imprisonment have we seen? in Europe? And secondly, what role do alternative approaches play in changing prison trends? I'm going to focus on the period since 2000, and I'm going to make 4 key points. Firstly, Europe's prison population has actually bucked the global trend. So in Europe, prisoner numbers have declined, while other continents have seen big increases over that period. Secondly, there are, though, very big differences between the various parts of Europe, and there's really no room for complacency at this stage. There's a lot further to go. Thirdly, greater use of alternative measures can help to reduce reliance on prison, but they can also be counterproductive to that goal. And fourthly, we should not be promoting criminal justice alternatives for problems that are better addressed outside the realm of criminal justice altogether. So for the first point, let me take a quick look with you at global prisons data. At ICPR, we host the World Prison Brief database, and our data show that the world prison population currently stands at around 11 million. In just 2 decades, the number has increased from about 8.7 to 11 million, with no real equivalent increase in space, staff, or other resources. Female prisoner numbers have increased by over 50% over that time globally, whereas the male prison population has increased by just under 20%. And typically, women are not convicted of violent or serious offences, and that's important when you're thinking about alternative approaches. Also, older prisoners, the proportions of older prisoners are growing really fast, and typically these prisoners also present less risk in the community. So where does Europe fit in this global picture? Well, the increases of the past 2 decades, as I've seen, were really much across the world, all continents except for Europe. In Europe, there was an overall decline of 20% in prison populations in the continent as a whole. But European data really offer quite a mixed picture. So the median prison population rate for Western European countries is 81 people per 100,000 of the national population in prison, and that is very low. By contrast, in the group of countries spanning Europe and Asia, so also part of continental Europe, countries like Russia and Turkey, the median rate is over 4 times that high. It's about 268. So that is actually very similar to the median rate that we're seeing in Central and South America and Southern Africa. So what has happened to prison numbers during the pandemic? The latest data for Europe suggests an average reduction of over 6% in the total number of prisoners across Europe. But much of that was actually due to lockdowns and court closures, not to deliberate policies to cut the use of custody. So I think numbers will begin to creep up again if more targeted measures are not taken. And this really matters because severe prison overcrowding still blights some European countries. At least 12 are currently quite badly overcrowded, some of them in the EU itself. And by contrast, occupancy rates are very low in other countries in Europe now, such as Ukraine, Northern Ireland, Latvia, the Netherlands, Norway. And all of these countries right now are less than 76% occupied, which makes it a lot easier for them to control coronavirus and achieve better outcomes from incarceration. Pre-trial detainees, obviously a big focus for the European Parliament again now, and they are a big concern in Europe. Diana has reminded us of the imperative to keep people out of pre-trial detention wherever possible. And here, alternatives, I think, have perhaps the biggest part to play, because the pandemic led to court shutdowns. Many trials were held up, and prisoners are now spending longer and longer on remand. And there are 18 EU countries where over 20% of the prison population are pre-trial detainees. The numbers are particularly high in Denmark, Belgium, and Luxembourg, where between 35 and 45% of detainees are pre-trial. So moving to alternative approaches, how have European countries been using these? Well, as you've both mentioned in the introduction, there has been a marked increase in the use of community-based measures and sanctions over this period, and there has been some research on how they have been impacting prison population rates and crime rates. So, I mean, what are the most common types of measure used? Fines are very, very commonly used. Community sanctions, such as unpaid work, are also very common. Supervision or control without rehabilitation. So, for example, suspended sentences, curfews enforced by electronic monitoring, and finally, supervision or control measures with rehabilitation. For example, a component of access to training or education, drug or alcohol treatment, supported by probation supervision. How about their impact? Well, unfortunately, these measures can enlarge the sphere of penal control by outlawing more and more types of conduct. And we've seen this happen around antisocial behavior and immigration control, particularly in my country, but in parts of Europe also. These offences often attract non-custodial penalties, but the problem is they still expand the population of criminalized people, and they can also increase prisoner numbers when people are jailed for non-compliance or for repeat offences. So, for example, fine defaulters make up 7% of Germany's prison population, and the figure is about 4% in the Netherlands and Switzerland. And that obviously needs a rethink in this day and age. So what's the evidence of the impact of Europe's use of alternatives? Well, it suggests that we really need to be cautious about seeing alternative sanctions as the holy grail towards lower incarceration rates or lower crime rates. A big study in 2015 looked at 2 decades of data on community sanctions and imprisonment rates. And it found that not only did these sanctions usually fail to reduce a country's prison population, it also had no effect on crime rates. And research by the European Prisons Observatory in 2016, which I'm sure Alessio will touch on, it found that prisoner numbers go up when governments keep on increasing the number of offences punishable with prison, and also when they keep passing laws to lengthen the time that people spend in prison. And all of these policies have become more and more common in EU countries in the last 2 decades. So just to wrap up and looking ahead, the pandemic has shown what European countries can do in an emergency. Many acted really quickly to reduce prisoner numbers to stem the flow of coronavirus cases. And we really need to build on that now. To tackle high prisoner numbers, we have to reverse the trend towards ever longer prison sentences and easier resort to custody. And in our response to low-level sort of nuisance behaviours, we need to refocus interventions away from punishment and control towards meeting underlying social needs, mental health and drug treatment needs, affordable housing, education, training. Otherwise, by simply promoting alternative sanctions, we will just be punishing more people in a different way. So thank you very much, and I look forward to questions. Thanks.
Thank you, Catherine. You're making a very, very strong point on a global response indeed. Matilda, I'd like to turn to you and ask you in FRA's view, and I know you've also issued a report, and I think it was in 2015, if I'm mistaken, and I know how complicated it is to have recent data. So 2015 is recent enough, I think, in this case. I'd like to say, what do you see? How are EU countries implementing alternatives to custodial measures? Do you still see room for improvement within the current framework? What are the options for member states? What are their limitations?
Mm-hmm. Hello, thank you so much. Thank you for inviting FRA to this webinar. Indeed, I would like to note that our research on non-custodial measures or alternatives to detention dates back to 2015 with the publication date in 2016. So it's not the freshest data we can imagine. In our subsequent research, we did touch upon these issues, however, not as systematically as in 2015. I will start with the legal framework, what is covered and why it is important, and then I will speak about use of these instruments and practice and recommendations. First of all, what I would like to say, FRA researched legal instruments concerning criminal judicial cooperation in criminal matters. So we did not research per se national laws as such. However, while researching these two instruments, which I'm going to talk about, we were able to assess what alternatives, what kind of non-custodial measures are available in national laws. So this how we gathered the data. And if I can ask now our colleagues to display the slide number 1 when I have the names of the instruments we did research. I'm talking about now Council Framework Decision 2008-947 on the principle of mutual recognition to judgment and probation decisions with a view to the supervision of probation measures and alternative sanction. It's a long title. Basically, it's about, okay, I don't know what I'm seeing now, but.
It's now visible. Yes, we have your first slide. Oh no, this is the title slide, and I think
this is the title slide. Yes, and yes. So this is about you can see the first probation and alternative sanctions is about pre-trial. No, it's about, of course, post-trial. I'm sorry, it's about post-trial. So this is the first framework decision that we're talking about, and then we have European Supervision Order, which is also a framework decision. And this is a pre-trial. And so these instruments we did research. If I can please ask to shut it, no, maybe shut it down, turn it, or I can hide. I'm sorry, I'm now confused because I have only one. Oh, yeah, it's fine. I have only one screen. I'm working now from the laptop and I'm not so used to that, but okay. So we can see we have two framework decisions, and these decisions, they do apply in judicial cooperation in criminal matters. We all are familiar, of course, with European arrest warrant, so we know how it works. One member state issues a decision, and then another member state supervises this decision. So this is basically the mechanism. And one member state, if it's pre-trial, issues a supervision order, and then the person that is concerned by this supervision order can stay in the state that is, I don't know, a place of residence, work, or study, and the executing state, and this supervision order is recognized and supervised there. It's all about alternatives, so it's all about non-custodial measures. And then when we talk about post-trial measures, it's basically the same. One member state issues a judgment or a decision, then it's transferred to another member state where this non-custodial measure will be executed, supervised, so this person can reside in a different member state. What is covered? And now I can ask for a second slide, because here we have, yeah, please. Here we have a table, and this is the result of our research. Yes, I am aware that it might be not so visible because it considers 28 then member states and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 measures, non-custodial measures. Therefore, I do encourage you to open up our report that is available online, and it can be consulted there. And this is the measures that we ask member states whether they have it in the law and whether they use it in the law. And obviously, using detention during the pre-trial phase should not be default practice. We know that alternative measures should be the first resort, and detention only used were strictly necessary and for as a limited length of time as possible. And this is clear from a range of international human rights and criminal justice instruments, which agree that, first of all, the presumption of innocence should lead to a presumption in favor of liberty, meaning that rather pretrial detention should be the exception and not the default. However, what we found during our research, that legal and cultural traditions of member states differ. And this is what basically plays an important role in responding to alternatives to pretrial detention. And for example, in the common law approach, and our research from United Kingdom and Ireland demonstrates default of the bail. And then detention might be only an alternative to the bail. And I was thinking about all of this for years, and even what language we use. We use alternatives to detention, which determines that maybe detention is a first choice, and then there are alternatives. And what we see from common law states, from Ireland and the UK, that it's a different way around. So this is something very important to note, that in other states in continental Europe, pretrial detention is perceived as a measure of a first resort. In some countries, the prosecution is the most powerful stakeholder driving the use of pretrial detention, and judges will, for different reasons, often comply with the prosecutor's requests. So to effectively and efficiently reduce the use of pretrial detention, it would be crucial to convince prosecutors to request alternatives. European Supervision Order, the framework decision, lists the pretrial supervision measures to which it applies. And these are obligations to inform authorities of any change of residence, restriction in movement, in particular in entering certain places, or an obligation to remain at a specific place, as well as limitations on traveling across state borders, and restrictions on contacting certain persons. Additionally, member states can notify the Council that they might also choose another measures. For example, restrictions on engaging in certain activities, restrictions on driving a motor vehicle, obligations to deposit a certain sum of money, obligations to undergo certain treatment, restrictions on contacting specified objects. So there is an array of measures possible. I will not now describe all these measures and in which member states they are available, because of course of the time constraints. But in our report we did do that. And what is seen from, for example, from this table, we see that, for example, restriction of movement is applicable almost everywhere. So this is a valuable data and useful data to consult if needed. And if I can now ask for another slide, which illustrates, the next one, yes, illustrates the post-trial detention. So then we did the same. We asked member states what measures, non-custodial measures, are available in those member states when it comes to the post-trial, so basically punishment. And we can see that. And in the framework decision, we have a definition of alternative sanction as a sanction other than a custodial sentence involving the privation of liberty or a financial penalty, imposing an obligation or instructions. So we know what is about. Probation measures are obligations and instructions imposed by a competent authority on a natural person in accordance with the national law of the issuing state in connection with a suspended sentence, a conditional sentence, or a conditional release. So again, we ask member states what measures they have available, what measures they use. why it is important. Yeah, very often what Katrin already said, detention may seems the logical option for dealing with suspects, accused, and then sentenced person. But non-custodial measures are very often a better choice. The fundamental right to liberty should only be limited when absolutely necessary. We know that principle. People are presumed innocent pre-trial. We know that principle, and therefore detention should not be a rule. Then again, greater use of non-custodial measures would have a positive impact on fundamental rights generally, because of course we know detention is very intrusive. If it's less used, social rehabilitation would be facilitated by not removing this person from society in the first place, and persons would be able to maintain or establish contacts with society and family, which is very important. So alternatives to detention support respect for right to family life, as well as the right to dignity. So there is no doubt that detention should be the last measure, but in certain cases, it is the only measure possible. So we also need to agree on that, both as a penalty, as for protection of victims and society in general. But it is still important to consider alternatives, to examine whether non-custodial measure would be suitable in this case. It is clear that in general, those two framework decisions seek to promote social rehabilitation. Very important, family life, very important. However, what we found out, these two decisions, they have been not frequently, at least in 2015, used. They were either forgotten by member states or overlooked, or maybe it was a question of just a habit of using the European arrest warrant, which is of course ingrained now in our brains. We know how to use it. It's easier, although these decisions are also easy to use, but maybe not so. People are just not used to them. So we were trying to collect promising practices about the use of these instruments, and this was very difficult because member states, they did not have promising practices. In Ireland, we were able to learn about the international desk as probation service, which will facilitate transfer of these non-custodial measures either from Ireland or to Ireland. So that was the only one. Also, although in England and Wales, we were able to collect this promising practice, but not in other member states, which shows the underuse of these decisions.
Matilda, we're running a little short on time. If you can get close to wrap up, please.
I will get close to wrap up. Thank you so much, Florence.
Thank you.
Basically, what else is very important, and this is the last thing I want to point out, the discriminatory effect of certain national laws, where in certain member states, there is this rule that non-custodial measures are used upon the condition of having the physical address in the state, which of course runs risk of discriminating other nationals of other member states, which also should be avoided. And I will finish now. More opinions, recommendations are to be found in our report. Thank you so much, and sorry for going over time.
Thank you so much, Matilda. I'm now looking to Alessio. I've introduced your work with EPO and with Antigone, and today we'd like to ask you to tell us about Italy. Antigone's reports are showing that the use of alternatives and non-custodial measures are increasing regularly in Italy. Can you tell us more about what these measures are and how, as Antigone, you see the potentials and the limits?
Thank you so much, and thank you for the kind invitation. It's been a pleasure to join the previous meetings, and so now I'm particularly happy to have the possibility to present some of the information we collected over the last years regarding alternatives to detention. The situation in Italy has changed significantly over the last 15 years, I would say. This is the present situation at the moment. At the moment, we have 53,000, more than 53,000 inmates, and more than 67 people now serving community sanctioned measures. So nowadays, the number of people under other criminal measures other than detention is more than the number of people in prison. And in this group of people serving community sanctioned measures are not included the measures, the pre-trial measures, the cautionary measures. So these are people either serving a sentence or on probation before and instead of the trial and of the sentence. We will see about that. So now we have a significant and to some extent also lengthy experience of alternatives to detention in the country. These pie charts present the major kind of alternatives to detention we have in the system. What we call misure alternative are measures generally issued after the sentence and in many cases after a period of detention, and are the traditional backbone of our system of community sanction and measures. But there are also new community sanctions. Let's consider this sanzioni comunità, which is mostly public service work for minor offenses, or messa alla prova, which is nowadays extremely significant, as you can see in the numbers, and regards people that instead of, for minor offenses, instead of going on trial, they, so before the trial and to avoid the trial, they enter a probation period with the various kind of content of the measure. Positive content can be very different under this messa alla prova measure. This is the overall trend of people under, so that's the net widening effect. Since 2018 to 2021, so that is after our last general pardon law, the number of people under a criminal measure has been increasing almost constantly, with the exception, as we can see, from 2011 to 2014 due to the Torreggiani decision, and more recently due to the pandemic. This data is split here. So above you have the number of inmates. This blue one is the general trend of community sanction and measures, which has been increasing constantly since 2008 without a significant reduction of prison population, which in fact has been increasing more steadily in the same period where community sanction and measures increase more steadily. So I would say that for most of his time span, for most of this period, in fact, community sanction and measure did not manage to reduce prison population. And when prison population decreased, as I said, after the Torreggiani decision of the European Court of Human Rights or during the pandemic, it's also it was mostly due early release scheme or other measures that are not part of our traditional set of tools that we consider our alternatives to detention. So the Italian case is not a case where we can see a big success in reducing prison population thanks to the increase of community sanction measures. But another point I wanted to touch regards the content of the community of these measures. Our traditional misure alternative were a set of measures where instead of detention or instead of beside a reduced amount of detention, you had a positive intervention by social workers and in supporting the inmate in reintegrating into society. The new kind of measures tend to have a more retributive approach. That is, instead of detention as a punishment, you get a different punishment, but a punishment nevertheless, which has mainly a retributive content. As prison in the past, also this content is expected to have some kind of re-educational and resocialization effect per se. But that is expected by the sanction, by the punishment, not by tailored measures supported by social workers that, you know, the clearest evidence is that the huge increase of alternatives of community sanction and measures that you can see here has been realized with exactly the same staff of social workers. We had at the beginning of this in 2008, in 2010, we had exactly the same staff of social workers taking care of alternatives to detention that we have nowadays. So now we have a wider set of sanctions, but most of these sanctions seems to rely on new forms of retribution instead of a serious attempt to tackle the many factors that usually are at the origin of offending and of reoffending. So to some extent, the situation in Italy now presents a new version of the old dilemma applied now to community sanction and measures. Instead, we don't seem to have yet decided what the future will be like, whether we want to keep resorting to retribution in a new and possibly more modern and less violent and less dangerous for the factors that we mentioned before, the risks attached to detention, but at the same time, or if we want to invest in social reset, in active measures to promote social reintegration and therefore reducing reoffending. I think that's the dilemma we are facing now as a system of alternatives to detention, and probably the next steps the country have to make is to try to assess the effect of these two different kinds of alternative to detention. What impact do they have on reoffending? What impact do they have in family links, in job placement, etc., and try to move from that. Thank you for your attention.
Thank you so much, Alessio. Very rich presentations, and indeed it's a very, very complex subject, so time is obviously short. I'd like to invite people from the public. If you have any questions, you can send them in the Q&A session. I have one or two myself, but I'd like first to ask if any of the panelists have a question or a comment to address to any of the other panelists. Catherine, we don't have your microphone, but I don't know if that's a question or if that's a no.
No, I just wanted to notice with Alessio's presentation on the numbers, the very rapidly rising numbers of people subject to community sanctions and measures. It will soon overtake the number of prisoners, but that happened in England and Wales a long, long time ago, and we now have 4 times as many people under probation or other similar measures, whether pre-trial or more commonly post conviction. So we have about 250,000 people at any given time now are subject to some form of community-based sanction or measure. And it places a massive burden on the probation system, and it obviously has done very little to stop the more serious forms of offending. Those are the forms which are on the rise in England and Wales now. So there's obviously better approaches available.
Thank you. That's close to one of the remarks I had, or one, I don't know if it's a question of a remark. I feel that in all your presentations, you've mentioned the challenge of habits, of the cultural dimension, and in a way of the security trend, which is by default, inventing more sentences. What have you observed in your contexts that can be done in terms of addressing this multi-layer change, like paradigm change that should be there? And Catherine, I think you mentioned that quite well, that the question of addressing underlying social needs versus providing security response. Do you see that catching at all? And maybe that's also a question to Diana and to Saskia. You might address that in your closing words, Saskia, but what can be done on the political level, on the research level, to try and change that paradigm?
Shall I respond first? I mean, we've done quite a lot of research on all of the factors that feed into overcautious pre-trial decision-making. And we've looked at sort of judicial attitudes, overcautious feelings of, okay, what might happen if my defendant does commit another offence whilst out on bail? I'm going to get killed on social media. It's just so much easier for me to, tick the box that he still presents a risk of reoffending or a risk of flight from justice. So there's a lot of box ticking, even in the really progressive countries such as the Netherlands, when it comes to, being proportionate in the use of prison sentences. The Netherlands is, one of the leading countries, but they seem to have a bit more of a problem in changing judicial culture around the use of pretrial detention. In terms of responses to crime, in terms of the sanctions available, I mean, I remember the example of Latvia from when we were looking at, which countries really had taken more than just a tokenistic approach to turning around really high prisoner numbers. And Latvia basically introduced a suite of measures. So it decriminalized a number of behaviors. So it turned them into sort of civil wrongs, those very low-level nuisance things which had been creeping into the criminal justice system. And secondly, it made a lot of criminal offences no longer ones which could attract a prison sentence at all. That seems to be much more effective than, for example, introducing a presumption against short prison sentences, which for many reasons is problematic. I mean, actually, countries in the Nordic area and the Netherlands, they do make a lot of use of short prison sentences, but that's instead of longer prison sentences. It's not instead of alternatives. And in thematic areas, things like diverting people with unmet mental health needs straight into a mental health care situation where their needs can be assessed away from a police station and in a mental health treatment setting is something that's worked really well in England and Wales. And people who get caught up in criminal justice systems merely because of unmet mental health needs, undiagnosed problems are really high in many parts of Europe right now, as in the rest of the world. So there's just a few thoughts. That's what we found. It's becoming a bit of a problem that whenever the state decides to introduce measures to improve the use of non-custodial sanctions, they always think it's important to do something on the other side to make prison sentences for more serious crimes longer, or to have more offences that need a label and need a prison sentence. So it ends up being you give with one hand and you take away with the other with your justice policy if you engage in that kind of mixed messaging, I would say. So I think steer clear of that and make a real political commitment to across the board reducing the use of incarceration.
Thank you. There's two questions that came in. I might just share them with you, and this way you can, one is specifically for Italy. So Alessio, you're responding to the question of the percentage of, it just went the other way. The percentage of Italy prison population, which is foreigners with non-Italian citizens, and you said 31.7. So that's 31.7 foreigners, right? Non-citizens. Okay. And the other question was about, and I think that relates also, Catherine, to something you said. The question is, in terms of alternatives, which ones seem to be the most effective and accepted by the public so far? What I understand from your answer, Catherine, is that it's not one in particular that's effective. It's a set of measure and a form of a holistic approach. I'm not sure that's what the public sees. I don't know.
Yeah, there was some interesting research on this very recently by Crest Advisory, which found that people who are asked, whether they would prefer a short prison sentence to something happening in the community, they definitely felt that time in prison was usually counterproductive compared to something that was involved more of a rehabilitative approach that would get to the root causes of offending. So I think the public, certainly in England and Wales, really do understand how counterproductive even a short time in prison can be. So the public is not nearly as punitive as politicians like to make out, and often the rationale that politicians give for use of prison is that the public expect it. But the research on public attitudes suggests it's a far more nuanced picture than that.
Thank you. If anyone else wants to react either with their answer or with a general comment, Alessio, please.
Yeah, one trend we are registering now is the one I mentioned before. To one extent, yes, there is this awareness that time in prison usually can be counterproductive or dangerous for in many respects. But at the same time, there is a growing tendency to rely on, for instance, for quite a while we have seen prisoners cleaning parks. So some kind of public service work displayed in front of the public. So this idea of giving back to society by the offenders, there is a lot of support there. But at the same time, as I said, the content of this measure is entirely retributive. It's a different kind of punishment. It's a more palatable kind of punishment, but it's purely a kind of punishment nevertheless. So it's very likely to be prone to the same shortcomings that different kind of shortcomings, but of the same kind you meet when you don't meet the basic needs of the offender.
Thank you, Alessio. That's a very strong point. I'd like to turn to Saskia. If you agree, Saskia, you'd like to give us a few closing words before we wrap up and finish. Sorry, and I didn't introduce you. I just said Saskia. I said Saskia Brickmont, which is member of European Parliament and also a member of the Greens Party. Sorry about that, Saskia. I said that. But over to you for a few closing words.
Thank you very much. Merci beaucoup. Je vais pour ma part parler en français. Comme ça, pour les personnes qui veulent changer d'interprétation, il est possible de le faire. Alors, merci tout d'abord aux intervenants pour vos interventions réellement intéressantes et constructives. Merci évidemment aux participants aussi, à Prison Insider pour l'organisation, avec ma collègue Diana Ribaï-Giner, avec laquelle on travaille étroitement sur ces questions. Et merci à elle de m'associer à cette séance qui est vraiment complémentaire aux travaux qu'on mène jusqu'à présent. Il y a une réelle urgence, un constat largement partagé qui est la nécessité de baisser la population carcérale, une nécessité qui est liée à des questions de droits fondamentaux, hein. Les panélistes l'ont largement évoqué, mais aussi vu les conséquences, pour des questions de conséquences sur les personnes qui sont condamnées, la rupture des liens familiaux, la rupture de droits sociaux et économiques, les difficultés de mettre en place un projet d'intégration et j'en passe. Alors, la question qu'on se pose certainement tous, c'est pourquoi persister finalement à détenir des personnes si il s'avère que la détention n'aide pas à leur réhabilitation ni à leur réinsertion. Plutôt que de revoir le système carcéral, de revoir le système d'enfermement, plutôt que de n'utiliser la détention qu'en dernier recours, on assiste à un usage de plus en plus fréquent, dans certains pays en tout cas, à la détention. Et la mise en place d'alternatives serait-elle inaudible face à la pression liée au risque, à la sécurité, à un discours toujours plus sécuritaire qui émane avant tout, et là je rejoins ce qui a été dit, des discours politiques davantage que de l'opinion publique derrière laquelle les politiques ont tendance à se retrancher. Or, la session d'aujourd'hui nous montre à souhait que les alternatives existent. Elles sont même nombreuses, sous-utilisées par de nombreux États membres. Et donc, il est de notre rôle, Diana, moi, les autres députés impliqués, la Commission européenne, évidemment aussi, avec laquelle nous travaillons étroitement, d'amener les alternatives, une guidance aussi pour les États membres, pour les pousser vers le recours aux alternatives à la détention. C'est aussi ce vers quoi le Conseil tendait dans ses conclusions de décembre 2019, étant donné que le Conseil allait en ce sens, soutien aux mesures alternatives à la détention, soutenu aussi avec insistance par plusieurs institutions européennes depuis avant ça, depuis les années 90, tant par le Parlement européen que le Conseil de l'Europe. Et c'est d'autant plus pertinent aujourd'hui, en 2021, que le coronavirus est passé par là et que l'on voit quelles sont les conséquences graves sur les détenus, les droits fondamentaux des détenus et de leur entourage de cette surpopulation carcérale. Et c'est peut-être maintenant que ce moment est là, que ce moment politique est là, aussi par rapport à une opinion publique qui a été davantage sensibilisée, touchée par la situation globale, mais aussi par la situation dans les prisons, que nous pourrions agir. Les alternatives qui doivent s'accompagner de financement, de services d'insertion et de probation, de la formation des professionnels à l'approche restaurative plutôt que répressive. Et évidemment, j'ai envie de dire évidemment, même si c'est pas évident pour tout le monde, les mesures d'alternatives ne sont pas une fin en soi, elles doivent aussi être vues, et certains intervenants l'ont souligné, comme faisant partie d'une approche globale visant la décriminalisation, ce qui amène à s'interroger réellement sur la peine, sur sa portée, son sens, les politiques de sanctions et de répression pénale qui doivent être revues dans leur globalité. Mais aussi aux personnes auxquelles ces peines sont appliquées, puisque, ça a été dit en mots de fin, beaucoup de personnes finalement n'ont pas à se retrouver en détention, beaucoup de minorités racialisées sont surreprésentées, ou encore des personnes qui souffrent de problèmes de santé mentale ou qui sont dans des situations socio-économiques précaires. Bref, ce vers quoi nous voulons tendre au niveau européen, au niveau politique, ce sont des standards communs à l'échelle de l'Union européenne qui, par des exemples de bonnes pratiques, qui remontent aussi des pratiques de terrain, comme les vôtres, nous montrent que nous pouvons réellement envisager ces standards communs à l'échelle de l'Union européenne, puisque aujourd'hui, ça a été largement étayé, eh bien, les recours aux peines alternatives sont réellement disparates, sachant que certains prennent vraiment la non-détention comme norme par défaut et d'autres l'inverse. Et c'est aussi, et je conclurai par là, un prérequis au développement de l'espace européen de justice que nous voulons renforcer. Je vous remercie toutes et tous pour votre participation.
Thank you very much, Saskia. Thank you to all the panelists. Thank you to Diana, and thank you to all the participants. I'm very happy to have had this very interesting conversation. If you would like to be informed on the upcoming webinars and on any other news, you can sign up to Prison Insider's newsletter. It's every 2 weeks. It's on our website, presoninsider.com, and that's also where we inform on webinars. And later today, for those that are still hungry about the topic, there's a conference held in Tunisia by the Tunisian Organization Against Torture on the decriminalization of poverty, and that's done within the framework of the campaign to decriminalize petty offenses. It's, as far as I know, in English, in French and Arabic. There might not be any English, but you can find information on the Facebook page OCTTUN, so OCT Tune for any information. thank you very much to all the panelists, and have a very good day. Goodbye.